Yes, Mr. Humphreys.
May it please your lordships. I appear for the appellant, Mr. Corbett. The learned friend, Mr. Brett, appears for the respondent's counsel. The interested party, Miss Wilson, has been served but does not appear and is not represented.
Yeah.
And that was the position below. The interested party simply filed a witness statement alone.
Yes.
Mr. Corbett was a litigant in person in the High Court with administrative assistance from my instructing solicitors at that stage.
I say yes, thank you.
Lords, this is an appeal against the order of Mrs Justice Jefford, dated the 17th of June of last year, whereby she dismissed the appellant's claim for judicial review of the grant of planning permission, a planning permission which had been issued on the 3rd of February of 2020 by the respondent council. And that planning permission was for the construction of a dwelling house and garage accommodation. It was integral to the house, the garage accommodation. And that dwelling house, garage, in the grounds of Beacon House East, which lies as the committee, the council's committee, planning committee concluded, to the west of and outside the settlement of Trevarian in North Cornwall.
Can I just ask you to pause, because it's a point of fact that I'd just like to be absolutely clear about straight away. Can we find a suitable map to identify both Beacon House East and Beacon House West? Is that possible?
Yes. Well, if the lordships go, Beacon House West and East, they are one property.
Yeah.
And I'll just take the lordships to
Yeah.
to best.
Is 16E quite good?
16E.
16E. The text is, certainly from my
From the planning statement. Yes.
eyesight, far too small, but I think you can identify for us where it is. I don't know whether that's...
No, I think Lord.
Can I just say, as I understand it, looking at 16E,
Yes.
it's the house on the left, Beacon House East and Beacon House West. The sort of...
Yes.
Right?
May I just check one matter?
Yeah.
Yes. Well, I just wanted to be.
You've got a better one?
Yeah, that is right. As shown there, Beacon House West and East, but they are
So Beacon House East is the
northerly one.
is the more northerly,
More northerly.
and Beacon House West the more southerly,
Yes.
and then the garage, which was to be demolished, I think.
Yes. That is just north and east, northeast of Beacon House East.
And is that actually shown?
That's not shown
No.
on 16E. That is, I think probably, if one goes please to page 30, page 40.
Yeah.
Page 40 of the supplementary bundle behind divider 5, the proposed site plan, we can see Beacon House East and then north, I think it's northeast technically, of Beacon House East.
Yeah.
And that replaces, it's not on the identical footprint,
No.
in fact it comes forwards, more towards
Yeah.
the...
Oh, no, that's very helpful. So if we have those two drawings in front of us, or the map and the drawing, then we've got the main features of the site that we need to know about, at least at this point,
Yes.
in front of us.
And 37 also shows it in sort of closer detail, the overall
Yes. Yes.
position.
I'll come to that in a little more detail in a moment, but I hope that's enough. Just
Yeah, no, that's very helpful.
But on those, they show Beacon House West and Beacon House East as being detached from each other.
Yes, I've always understood them.
I had always understood them to be part of the same structure.
That's what I had understood, which is why
I had perhaps mistakenly thought that the second building that one can see against which situates, say, Beacon House East was in fact the garage.
Well, that's I was also. I thought they were one building.
And indeed, the judge refers to Beacon House, simply Beacon House, I think.
That's right. I've always understood East, and effectively joined, but with
one can see that most clearly, surely, on page 47, where you can see the separate building is the garage.
Yes, 47 is the garage building, which is
with Beacon House East and West, as I had understood it,
yes,
being the stone building to the left.
Yeah. That's as I understood.
So, although you received confirmation from behind you,
yes,
I'm not at the moment sure that the building most proximate to the words Beacon House East on page 16E is anything other than the garage.
No, I would respectfully agree.
Can we proceed on that basis?
Yes.
I think what has misled us all perhaps is the notation on the map at 16E.
Yes.
Whereas Beacon House actually is the as we look as it were in the more southerly of the two buildings, which is divided east and west.
Yeah, exactly.
And that would overcome the oddity that it's north and south rather than east and west on any other view of it.
Yes.
It's slightly strange, assuming that north is to the top. So, as my lord says, the wrong way round L-shaped building, uppermost as it were, is in fact the garage.
Yes. When it was a beacon, I hope that people.
So I think, whether all this is important or not, I don't know, but it is really helpful at this point just to get that.
I was going to come to that. I was just going to just by way of just to complete the brief introduction.
Yeah.
It was by order dated the 14th of February of this year that Lord Justice Lewison granted permission to appeal in respect of ground 1, which effectively is the correct interpretation of policy 3 of the Cornwall Local Plan.
Yeah.
Lord Justice Lewison adjourned ground 2 to the hearing of the appeal by this court. If I may, I shall address that issue later in my submissions.
Of course, yes.
My Lord, what I was proposing to do,
Yes.
show you the route, I was going to refer to the photographs and plans now,
Yeah.
then the officer's report to the relevant committee, the officer's addendum report, which was put to the committee either on the day or the day before, and the minutes of the committee, which were then approved by the following committee meeting in the usual way.
Yes.
Briefly then, to set out the legal framework and the principles relevant to the interpretation of development plan policy, which of course is very well known to the court, and I believe just about everything is common ground.
Right, no, that's really helpful. Just to help you and everybody else, the court has taken the opportunity to prepare properly for the hearing, reading everything, familiar with all the documents, so you can assume that safely as you go.
No, thank you.
So what that means in effect is that you don't need to read out passages as you go. You can bring them to our attention.
Yes, well, I'm grateful. Following the legal framework, then I'll go to the Cornwall Local Plan policies, the relevant national policy set out in the National Planning Policy Framework, and some case law regarding the meaning of that policy, and then submissions relating to the policy interpretation. I will at that point refer to a case referred to by Lord Justice Lewison when granting permission, and also a more recent decision of Mr Justice Holgate on some similar wording, albeit in a statutory context, just so that the court has it before it, is aware of another decision. Not that I think either party says that it's in any way determinative in this case, but just so that the court is aware of a recent decision of the High Court. My Lord, just to say that when one's reading the learned judge's judgment below, I say this just, I think it's relevant to say that the judgment was handed down some 6.5 months after the hearing. And obviously the judge was taking a careful note of all that was said, but it just, I've mentioned that because it must be difficult at that length of time to have in mind all the points raised. But there it is. I'm not going wider than obviously the grounds of appeal, nor do I intend to suggest there are other grounds. But I just bring that to the court's attention because that is a substantial lapse of time. Before I go further as well, may I just mention the court, having prepared as well as it no doubt has, the court may have seen in the supplementary bundle a witness statement prepared by Mr. Smith, planning officer of the council. Yeah. I don't ask you to turn it up, but there are some comments in just 2 paragraphs made regarding the bringing of these proceedings by Mr. Corbett. Now, I don't ask you to turn it up, so I've raised the matter with my learned friend outside of court, of course, and he has confirmed that there's no suggestion of any impropriety being levelled at the appellant for bringing these or any previous legal proceedings concerning the respondent counsel. And on that basis, I don't need to trouble the court further on that point. That witness statement was filed on as long as the 12th of November 2020, long before I was involved, which was this time last year. But when Mr. Corbett was a litigant in person, and I just felt that I ought to...
yes, no, quite right. But Mr. Corbett is I think, a parish councillor.
That's right. And I know he appeared before the Lordship in a Court of Appeal case also going by the name of Corbett against Cornwall in April of 2020.
Yes, he did, though as today represented by counsel. Can't recall.
I think it was Mr. Bowes.
Who it was? It might have been Mr. Bowes. Yes.
Yes.
Yes. He is a parish councillor. Of the St Morgan and Pidar Parish Council.
That's right. He doesn't bring these proceedings other than in a private capacity.
Yes.
But that, I'm instructed, is that the Parish Council, understandably not having any resources at all of its own to do so. So it's very much him bringing these proceedings.
No, we understand that, of course, yes.
Lord, apart from that, I'll leave that to one side. Now, Trevarion is a small settlement near to the coast in North Cornwall, to the north of Newquay and to the south of Morgan Porth. And as I've said, the proposed development lies to the west of the coast road, emphasise coast road, known as Trevarion Hill. I will, just before I go to the plans, just to say that the site is also located in what is referred to as the Watergate and Landherne area of great landscape value, but no issue of law arises in this appeal regarding the finding that no harm would result to that area of great landscape value. Lord, if we then turn to the supplementary bundle and divider 5, I will take this briefly, but I hope thoroughly. Divider 5, page 36, to identify first of all the location plan. On the location plan, one can see that the red line, which I would refer to as a pan with a pan handle, perhaps crudely, the red line is the application site.
Yes.
The yellow road is the coast road. The coast road meets the orange coloured road, which is the B3276 on the northwestern edge of Trevarion. One can follow the coast road.
Yeah, so the B road is the orange road.
Is the orange road. So, but the coast road is called Trevarion Hill.
Yeah.
Lord, on page 37, as we've seen, the next page, site plan shows the location of the application site, and more importantly, the location of the proposed development by that arrow. And as we've seen already, that is that really is probably the garage building that's shown.
Can you just help us with the base of this map?
Yes, this was put in as part of the planning applicant's planning statement
I
went
see,
in with
yes.
the planning application.
Yeah.
So,
So its status is it's an application document. It's not
That's-
a
that's
plan document as such.
that's right.
And sorry, while we paused on that theme, we don't have, I think I'm right in saying, but correct me if I'm wrong, any relevant extract of a proposals map or allocations map for the local plan, do we?
No, no. I don't think that there's anything.
I mean, the
I
point of
did. Did have a look at the
Yeah.
at the key diagram, and there's nothing of relevance.
Right, well that's really helpful. The key diagram doesn't have, at least for this settlement, a drawn settlement boundary.
No.
No, and so that, I'm not sure that's ever said in, such simple terms in the papers, but that is the position. On the key diagram, there is no settlement boundary for Trevaria.
No. And on page 38, one has...
Sorry, the yellow
Yes.
just signifies the extent of the property. The one looks at the yellow in the...
Yes, I'm not sure of the status of this plan,
Okay.
if that is
I
simply where there's...
would guess, though I don't know, I would guess that if this is an application document, the buff
Yes.
wash is intended to demonstrate what the applicant was saying constituted the settlement. I suspect that. I don't know that.
No, I don't know, but it may well be. I just paused. Yes, I just don't know what's been added to this plan, if anything. by
Okay.
it.
Okay.
Yeah, fine. No, well, that's the safe answer to give.
Yes. And page 38 is an aerial view, and I think that's it's as well just to reflect, first of all, what I refer to as the panhandle element of the red. Sorry if that's a rather crude term, but that's the driveway, and where shared, and that's shared effectively pretty well upward, where it opens up into the rest of the pan. That's a shared driveway, some 200 feet or 60 metres in length.
I thought that, forgive me for going niggling away, I thought that page 37 and 38 were part of the officer's presentation at the meeting.
Lord, no. I say no. I beg your pardon.
The index I've got
Yes.
suggests that starting in the paper bundle, because the pagination is different in the electronic bundle, the officer's presentation to the committee starts at page 34.
Yes.
And that means that 36, 37 are, whatever their original provenance, part of the officer's presentation.
My lord, that is correct.
Yeah, it is. My lord, and yes, I've mistakenly thought we were looking at the full planning statement, which, because of the reference to 16E earlier, I thought that we were still in that. That was put in as the whole document. That is at divider 4, the planning statement.
Can we just be clear? I'm sorry.
Yes.
Mr. Brett may be able to help us.
Yes.
Of course, these materials did comprise the officer's presentation pack, I think, for the committee meeting on this item on the agenda. But did they draw upon application documents?
My lord, I'm not sure I can answer that question. These were plans prepared by the planning officer for the purposes of the committee meeting.
Oh, I see, yes.
And I would expect in doing so, the officer would have taken maps from the council's own system. However, there was a plan attached to the front of the officer's report. Unfortunately, I'm not sure it's made its way into the bundle. I've just checked.
Yeah. Anyway, I think probably if those points need to be clarified, then they can be later
No, my lord,
in the morning. But
Yes, Lord Justice Stewart is entirely right that these were, as confirmed by Mr. Brett, that these were the slides, I think, which would have been presented to the committee by the planning officer that we're looking at, 37. So
Can I, well, if anyone else has got the enthusiasm to do it, one of the things that puzzled me in preparing for this is that the electronic supplementary bundle is different from the paper electronic bundle that we've got. And I've now just identified where the difference emerges, because both the electronic and the supplementary bundle start the Situate planning statement on page 16.
Yes.
The paper bundle then moves to tab 5 on page 22, so it only has 6 pages of the Situate thing. Whereas, and here may be a pot of gold, in the electronic bundle, the Situate planning statement goes from pages 16 to 33. But to be perfectly frank, I have not interrogated the difference any further.
No, well, I'm aware that some pages of the planning statement had originally been put in. We then asked that the whole full planning statement be put in. That's then been put in that way. That's why one has the numbering 16A up to 16, whatever it is.
But the Situate planning statement is in full, pages 1 to 17 of 17.
Yes.
And I've just looked at them, and they do not include the drawing that we were looking at from the officer's presentation a moment ago.
No, that's right. The planning. So these are.
I'm sorry to niggle. But
No, not at all. Not. I'm sorry not to have made that slip earlier.
All right. Well, look, we'll proceed on that understanding then. That the drawings you're showing us in the in the sequence from 37 and onwards are materials prepared by the officer for presentation to the members of the committee meeting, and rather than that they had the status of being application drawings or something.
That's right.
Right, that's fine. Understood.
I'm grateful. So we have. So I've referred to the driveway shared and the length of that shared driveway, which goes up to the end of the panhandle. And just pausing there, just a further aerial view is at divider 6, page 63, which just gives one the wider context. Obviously, the coast to the west. We can see Morgan Porth to the north, and we can also see where to the west of Trevarrion, where you can see the driveway and then the Beacon House, east and west combined there.
And this is said to be document 5 from the claimant's reply, dated the 28th of August 2020, in the index.
That's right. So I think some things from the High Court bundle, these weren't, that wasn't presented to the committee, but it was put in at the High Court stage by Mr. Corbett, but just as an aerial photograph to show.
Right.
Going back to divider 5, page 40 shows the proposed site plan as I've shown you, lordships, ready, and one can see, just looking at the detail there, the proposed site plan, a new house, then a garden area was to be created to on this plan to the left, I think it's northwest of the proposed house, and some drainage put in on the furthest east point, and then some, I think, going on there, we can see there would also be some. Yes, on page 43, just showing the proposed floor plans. I think one can see that where the garage is at the bottom of those, it's obviously the ground floor and the top floor above. And then there's just to the right, it's very difficult to read, but to the right of the garage, that's the bottom half of page 43, it says drive, I think it says gravel there. Gravel is existing, I think it shows. Yes. So that's page 40. Page 39, as I was saying, shows the outline of the of the existing garage, one can see, one orientates oneself so one can see the Beacon House at the bottom of this page, and then the existing garage and how it's going to, obviously that changes when it gets on to page 40. Both the garage, both the extent of it and also the laying out of the garden, the creation of the garden and the treatment plant, etc.
Could we just look at the photograph? Are you taking us to the photographs in a second?
Yes.
Yeah, no, fine. Well, I won't interrupt that.
Well, the proposed elevations one sees at page 41 and 42. One can see it's a two-storey, going to be a two-storey building, set slightly lower, somewhat lower than the existing Beacon House. I think that's probably, and one can see that as from page 42, the southeast elevation, that's as one comes up the driveway, goes off now what will be to the right. One will have the garage door below and then the living accommodation above.
Yeah. All right. You're going to take us to the photographs.
My Lord, I am. Page 44. This is obviously a proxy views because we can see from the bottom these are Google Earth photographs, I believe, taken the usual way from a camera mounted on a surveying vehicle. So it's not actually, so it's slightly above on the standing person's height. But anyway, we have the location of the driveway on Trevarian Hill is indicated as with that arrow on page 44, the application site. That's where the driveway begins on the, what I would refer to as the west side of the coast road. And that page 45 is looking from the other direction, looking back down the road. So this time the driveway is on the right-hand side, the beginning of that driveway headed application site. And that page 46 is if one was on the road looking down the driveway, one can see the existing Beacon House at the end. In this view, one can't see the existing garage, which is to the right, the end on the right. And then one comes down, so to speak, the viewer comes down on page 47, one comes down the driveway, and then we can see the existing garage building to the right of Beacon House.
Yes. Now, those two photographs, pages 47 and 48, show the, as I described it, the wrong way round L-shaped building, which is that single-storey building, which, if you look at the photograph on page 47, appears to show a double garage facing one, and then the protrusion behind that seems to be, if you look at page 48, a residential part of that building, unless I'm mistaking it, which has a window on that return elevation. You see on page 48.
Yes, I believe that.
What I'm wondering, and I may be wondering foolishly, is whether in fact that building comprises both a garage block and residential accommodation. Is that right or not? And I'm beginning to wonder, you see, whether in fact when we started off by differentiating between Beacon House East and West, whether in fact that building, that single-storey building, is Beacon House West, after all.
No,
that's wrong, is it?
That's
so what is that apparently residential element?
My Lord, if at page, within the supplementary bundle, at divider 3, page 9, we have the witness statement of the interested party.
Yeah.
And at paragraph 7, it says that the land to be developed as a site of existing garage and store to the east of my house. So completely separate from the house.
And that's the photograph.
It's a substantial structure consisting of a double-width garage with double-depth storerooms and an attached utility room and shower room. So that accounts for its mass, I suppose. So it's not just a garage; it's also storerooms and utility.
So that, when we look at the picture on page 9, that is the part of the building I was referring to. Is that right?
Yes.
Yes, I believe.
I think it is, and that is the building she is describing in paragraph 7.
Yes.
All right. So that, as we were then on Beacon House East and Beacon House West being the divided two parts of the single, mid 1800s building.
Yes.
To the south of that.
That's right. And just on page 10, again, one sees that building and then the side of it. There's 2 photographs there just to reinforce.
All right, so that all fits together then.
Yes.
The upshot being then that Beacon House East and West comprise a single building which was divided at some point, the original building, or else there was an extension to the original building. We didn't trouble with that, but it is in fact two parts of the same building.
That's right.
Yeah, fine.
And that's confirmed by paragraph 5 of the interested parties statement.
Yeah, thank you.
Page 5 of the intro. Oh, yes.
Paragraph 5.
Yes.
Beacon House has been
Oh,
divided
yes,
into
of
Beacon
course,
House
yes.
West and Beacon House
That's
East.
right.
Divided into, yes.
Yeah, no, that's really
Yes,
helpful.
I'm
Thank you for
grateful.
that. I'm grateful to you. Thank you.
Right. I think that's. May I just mention this? Obviously, we have an application site. We can draw an application site as large or as small as we wish to. And the relevance in this case is that the proposed development, by which I mean physical development, building, operational, engineering operations, and/or material change of use. There was no material change of use. It was already a residential. The only physical development, operational development that takes place is the house and its integrated garage and the laying out of the garden, which will be an engineering operation, flattening, removing trees, all the rest of it, diggers, and flattening it. So there's no alteration at all to the access where it comes on to the coast road. It's not widened, it's not resurfaced, nor to the whole of the shared driveway. In fact, one sees, I think, it says existing tarmac going up to the existing garage. So I focus on that because that is the proposed development. And that when we come to look at policy 3, we don't say the application site, because we have to say, where is the proposed development? Proposed development is very much after some 60 metres down that driveway and then a little bit more after that. From the shared driveway, it may be another 10 or 15 metres beyond where the new dwelling will be. My Lord, coming then to the reports committee, the addendum and the minutes, may I just highlight 3 points at the outset. It's common ground in terms of what the council, how this was determined, certainly taking the council officer's advice. First of all, that Trevarian has what's referred to as form, shape, and clearly defined boundaries. That's in the addendum, that's the addendum report, which is only 2 pages, which it's a supplementary bundle, divider 5, page 33. Just show your lordships that at this stage. What happens after the report has been prepared 5 working days before the committee, some representations are made, and then the officer on the day says, oh look, I just want to update members with any recent information. And we can see that on the second page, page 33, the officer response to the various points, the third bullet point down says, Trevarian is adjudged by officers to be a settlement because it's a well-defined group of dwellings with a collective name. It is a place where people live in permanent dwellings, which has form, shape, and clearly defined boundaries. And the there is, so that's the first point. The relevance of that is that when we come to the Cornwall Local Plan, paragraph 233, which for your notes and all its supplementary bundle, divider 7, page 83, in such circumstances, development which takes outside the settlement is deemed to be in the open countryside, deemed for policy purposes. And that's in relation to policy 7. The second point from the outset, again, the finding is that the development would not be in the settlement. The resolution, and the Lord, that is also behind divider 5, and the relevant part of the this is at page 60. This is part of the minutes of the Planning Committee. Sub-area Planning Committee on the 20th of January 2020. Page 60 says there that the resolution says in the, just to read it, the resolve that, halfway down the page, resolve that application be approved subject to the conditions set out in the report. The reasons given by the proposers, that would be the interested party, for wishing to, no, I apologise, that's the person who proposed the motion, for wishing to approve the application were that the proposal was supported by policies 3 and 21 of the Cornwall Local Plan, in that the new home would be on previously developed land immediately adjacent to a settlement. There they were using the words immediately adjacent. I don't say that may have been a slip. They might have meant to say immediately adjoining. But nevertheless, that is the resolution, saying immediately adjacent. But crucially, by saying immediately adjacent settlement, they're not part of the settlement. And in terms, importantly, when one's looking at the officer's report,
I think is the effect of that the resolution is the single sentence that the application be approved, and the reasons that are given is that the application was presented on the basis that it was immediately adjoining a settlement.
yes. And
So it's not actually part of the resolution itself. It's simply the basis upon which the application was made.
I think the proposer is the proposer of the motion.
Propose the motion.
And that was, are we told who that was on
That
the previous page?
is, it was moved by, yes, just
Oh,
above,
moved by
Councillor Thomas.
Councillor Thomas. Councillor Thomas, I think, is the proposer.
That's right.
And what the minutes record is what he, Councillor Thomas, he or she, Councillor Thomas, said when proposing the motion to approve.
That must be right.
I think strictly is what happened.
I respectfully agree.
Yeah.
But coming back to page 27 of divider 5 to the officer's report,
Yeah.
we'll come back to this in a little bit more detail in a moment. But
Is this point number 3 now?
no, this is still part of not being the settlement. Just to
Sure.
emphasise this second point, paragraph 23. The officer says that an important planning judgment required when considering this proposal against policy 3 is whether or not the application site immediately adjoins Tribunals. I ask you just to underline the word site. This is argued as the site and settlement are physically separated by a road. And just pausing there, the site and settlement are physically separated by a road. So the officer's advice is that it's the settlement edge of Trevarian is on the east, I'm going to call it the east side, right, of the coast road. It's not on the west side where we have the access going up to the driveway. Because,
where does it say east side? And why is that right?
well, this is the basis of what.
Where does it say?
Well, because
it says separated by a road. Where does it say that the boundary of the settlement is on the east side of the road?
Well, because if my lord, it's simply, I hope I'm fairly deducing from that if the site and the settlement are physically separated by a road, that the settlement therefore must be on the coming up to the eastern side of the road, because then the road, then the site. They're not saying, oh, the site and settlement are joined on the west side of the road. It must be, if there's a road in between, therefore the boundary, settlement boundary, must be on the east side of that road.
No, that answers my question.
So that, I'm sorry to labour that point a little bit, but that's just to yes. So that's the second point. The development would not be in the settlement. I think I ought at this stage, just to deal with the point before I forget. There's a reference by the judge and in my learned friend's skeleton argument to the fact that at first in its representations, the parish council made submissions to the effect, and I think this obviously is in response to the planning applicant's planning statement that the site was within the settlement. At least that's how it's we read it, as that was their submission. I say that because they refer to this being a rounding off, the development being a rounding off of the settlement. When we come on to the concept of rounding off of settlement, the definition of that within the local plan is within the settlements.
Well, I think he goes further, doesn't it? If you look at page 25, third paragraph under the heading 16, St Morgan implied our parish council, you read, although Beacon House lies within the settlement of Tridarian,
yes,
etc. Just to be clear, I don't think we've got, have we? I'm not sure if we have the parish council's letter of objection.
We haven't.
Well, the first question then is whether the officer here has simply recited verbatim what is in that letter of objection. Or would it be wise for us to have the letter, do you think, so we can check it for ourselves?
My lord, my understanding is this is verbatim. The officer has lifted the main text from the objection.
Right, so we can take it that the text running from the PC objects to this application, or at least from in order to comply with that policy down to should be refused, is verbatim what the parish council was saying by way of its objection.
My lord, indeed, the words of the parish council.
Right. So the parish council was saying that Beacon House doesn't differentiate between east and west, lies within the settlement of Tridarian.
But crucially, my lord, that this application is 11 and a half months before it's determined, which is not unusual. But, and one bears in mind that one has to put in one's response within 3 weeks of notification, because that's the statutory time period. That's what the notice would say. Well, first of all, ultimately it's what we're analysing here is the decision of the committee, not the decision of the parish council. But secondly, the parish council's representations evolve, and as we see from the addendum, which is their position immediately before the committee, their position has changed, and we see this at page 32. Yes, at page 32.
This is all put in quotes and in quotation marks. So this, I think, we can assume.
Yes, I think we can assume that is verbatim, particularly in the italicized text.
I think I would feel more comfortable if I had seen the letter referred to on page 16. Paragraph 16.
I will see if I can identify that over the shorter journals. And I'll see if I've no reason to doubt what the learned friend had said.
Nor do I.
But my lord, in what's there recorded on page 32, I think we can see in the, I'll just read it, the critical question raised by this application is whether the proposed new dwelling would be compliant with either policy 3 or policy 7. And so far as policy 3 is concerned, the proposal is clearly not an infill or a rounding off. Neither in the parish council's view can the site be regarded as previously developed land within or immediately adjoining a settlement. So, and they go on to say that it's a field between the coast road and the application site. So, and then it says in the next paragraph, just 2.5 lines in length, it's further the case that when shown an aerial photograph, what council thought is neither in or there. It wasn't me, but anyway, that's. But there, in other words, their position had changed in saying no, this doesn't accord the policy 3. It's not within or immediately adjoining the settlement. So their position had changed. I simply refer to that because obviously one reads the reports committee and the learned judge referred to this in her judgment, but didn't, obviously I wasn't there, but didn't go on to say that by the time it came to the committee, of course, their position had evolved. And of course, when one's just to be fair to the parish council, when one is faced with a position where people are saying that where it's been suggested by the applicant, this is within the settlement, it becomes the natural reaction. Obviously, there are many planning considerations considered, but one say, well, if you're saying it's within the settlement, then this is garden and it's not previously developed land, because if it's only if you're within the built-up area of the settlement that you it's treated as green field. So anyway, that's by the by. So the second point was then that the development had not been settlement, and I think the third point, just by way of introduction, is that the officer suggested that it was arguable that the site was immediately adjoining, but then applied a test or a criterion that doesn't appear in the policy. And we can see that at paragraph 23 of the report to committee. This is on page 27 of divider 5 of the supplementary bundle. The officer conclusion, the last 3 lines of paragraph 23, the officer conclusion that the site does adjoin is underpinned by the judgment that this proposal will extend the residential setting and function of Trevarian rather than introducing a new home of more detached nature.
But forgive me,
yes.
What then is the relevance of the fact that the planning statement, which is in tab 4, refers expressly to policy 3 and the rounding off of settlements and development of previously developed land within or immediately adjoining? That's on page 18 of the bundle.
Yes.
We contend that the proposal lies on the edge of the settlement of Trevarian, which has a clearly defined boundary formed by the main road.
Yes. Now, there's been some dispute about what the main road referred to there was. It was once, I think my client understood the main road there to be referring to the coast road. The planning applicant said, no, the main road there being referred to was the B road.
Well, what do we make then of page 21, which is page 17? As evidenced within this submission, this site meets the 3 key rules of sustainability as set out in the MPPF and also in conformity with policies 3.
But just pausing there, if I may, the numbering that you've given behind tab 4.
Page 21 of the paper bundle.
Sorry, I've just page 20 in the conclusions.
Yes.
Yeah, yes. Okay.
Second paragraph.
Yes.
Because you were suggesting a moment ago that the position of the parish council in its initial response was dictated by the fact that it was presented as being within the settlement, and that seems to me to be at odds with what is said in this planning statement. Because the planning statement, if it's a relevant document.
Policy 3, my lord. But the policy 3 reference, they were saying it was a rounding off of the settlement, and therefore within, to be a rounding off, we assumed that they had understood that meant that it would be within the settlement itself. I have to say, with great respect,
no, you're quite
planning
right.
consultant.
Second penultimate paragraph, the development of the site would conform to the principles of rounding off and previously developed land.
I have, with great respect to the planning consultants, they don't directly address the policies with great clarity.
The position seems to have been this, doesn't it, in short summary, that at the time of the preparation of the committee report, that's to say the main report, not the addendum, the applicant for planning permission, Mrs Wilson, and the principal objector, the parish council, were both, albeit in different language and for different purposes, were both contending that the site of the proposed development was within the settlement of Trevarian. Both were in different language. The officer preparing the report, however, took the view expressed in paragraph 23, which was that this was a site and development, as I read paragraph 23, that would be within, that would immediately adjoin the settlement rather than be within it. That was the position at the time of the preparation of the committee report. By the time of the preparation of the addendum, the parish council's position was one of criticising, I'll use that word neutrally, the officer's advice in the committee report, and the officer was addressing that criticism. And then the members discussed it, as we've seen in the minutes. But that seems to be the broad...
Yes. I wouldn't wish to be other than fair, so that to understand the officer's the role he had and what he was faced with at the time.
Yeah. No, well, that seems. I mean, that's what happens, and that is what happened here, actually. But I mean, the long and short of it is that we the court must look at the policy and conduct our interpretation of it. That's what the law says, I think.
Exactly similar. And the only reason for me referring
of course,
is because it's referred to in the judge's judgment, and one needs to assist the court.
No, well, you've done that very, very clearly, if I may say so. Thank you.
I think then, looking at the report itself to the committee on paragraphs 21 to 23, so this is pages 26 to 27, I perhaps just to go through a little bit more of the report in the light of what I've said. Just going back to page 22 first. Paragraph 2, the officer begins, this is under the heading balance of considerations and conclusions, so members often like to have a sort of summary at the beginning before the detail goes through. But so paragraph 1, full permission sought, construction dwelling garage within the curtilage of existing home, nearby to the settlement of Trevarian. 2, the proposal supported by policies 3 and 21, in that the new home is on previously developed land immediately adjacent to a settlement. That doesn't say, just pausing there, it doesn't say that the new home is immediately adjacent to settlement. It says the previously developed land, or it's certainly ambiguous there. It elides, as does policy, 2 concepts: the proposed development and the site and/or previously developed land. Is it the site, or is it here because the whole site is, because the red line site is regarded as previously developed land? I will refer to that as PDL for the moment rather than the application site. Is it the previously developed land which must immediately be adjacent, must immediately adjoin the settlement, or is it the new development also, the actual proposed development as a whole? When I say as a whole, that is the house and garden and all the physical features of that development. Is that as a whole immediately adjoining a settlement? At paragraph 5, we notice that there's a reference, paragraph 5, by the officer to the application site being within the curtilage of Beacon House, currently containing an associated detached double garage and building and garden, just to show that's detached. It's bordered by open countryside. That's a small point, and I'm not seeking as one judgment says, a flawless consideration of every single planning point, but just, of course, it wasn't just bordered by the open countryside, it formerly was part of the open countryside.
I'm sorry to be so slow, and I'm sorry to interrupt you. But were you criticising the terminology of paragraph 2 because it reflects directly the wording which we see at page 78, in principle the use of previously developed land within or immediately adjoining the settlement? Sorry, no,
Well, when I come on to my submission, when we look at policy 3 in detail, there's the way I think there are two ways of reading that policy, and I think it's elided. The grammar is such that it's unfortunately two issues have come together. It's the development and the previously developed land, which must be immediately adjoining the settlement. Not just here is previously developed land that immediately adjoins or otherwise, and here's the proposed house. That's it. Both need to be. Otherwise, one could have a long existing driveway or road going to a barn, a house, an industrial building, and one could say, well, one part of this comes close to or touches the boundary, and therefore we can have this development out here. And there's nothing in policy 3 to stop that, on that incorrect wording. So the development plan is an application in accordance with the development plan. One looks at the development plan as a whole. I think it's a feature one sees in planning. Anyway, I'm running
Sorry, that's my fault.
No, not at all. So paragraph 21 then on page 26, I've first paragraphs 2 and 5 so far, but paragraph 21, under housing development, the site is located within the countryside, both the countryside, yes. It is previously, so talking about the site, it is previously developed land by reason it contains the garden area of an existing home on land outside of a built-up area. Next paragraph. Policy 3 of the local plan supports new housing on previously developed land, providing that the site is located within or immediately adjoining the settlement. So again, we've got that problem with the word site. And that the scale of the proposal is appropriate to its size and role. I'll come back to policy 3. The application complies with this policy insofar that the proposed new home is located on previously developed land which adjoins the settlement. It's not there saying that the new home adjoins, let alone immediately adjoins the settlement. It's the previously developed land he's saying adjoins. And then he goes on, paragraph 23, and I just pause there. I'm not saying, taking the absence of the word immediately in paragraph 22 to criticise the officer, because in paragraph 23 he comes back to use the word immediately adjoin in 2.5 lines from the end of paragraph 23. It's the point, it's the elision of those two concepts, a misunderstanding of policy 3. So paragraph 23, an important planning judgment required when considering this proposal against policy 3, is whether or not the application site immediately adjoins Travarium. This is arguable as the site and settlement are physically separated by a road, and the proposed new house by the same road and a driveway, yet a new home on this site would be more immediately adjoining the settlement than not in terms of its setting and how it would functionally operate. Now, suddenly this one reference to physically separated by a road and the proposed new house by the same road and a driveway, yet a new home on the site would be more immediately adjoining the settlement. That's the only reference. There's no direction to the committee. Obviously, it arises if he's incorrect at policy 3. There's no direction to the committee. Look, the two things you've got to decide. Does the previously developed land immediately adjoin? What's immediately adjoin mean? And also, does the proposed development as a whole immediately adjoin? It really, apart from that one reference, but it's all sort of, I didn't mean this rudely hedging bets, but it covers points, but doesn't say how they should be directing themselves. And that's an important point in my submission. So then we can go on to paragraph 24. To ensure the best use of land, policy 21 of the local plan states encouragement will be given to sustainably located proposals that use previously developed land, provided they're not of high environmental or historic value, and increase density where appropriate, taking into account the character of the surrounding area and access, I think that should be, to services and facilities to ensure an efficient use of land. This proposal is supported by Policy 21 in that the site is previously developed land, is within walking distance of the facilities and services at Trevarian, including a bus stop, a school bus route and a public house, and as the new home is in keeping with the character of the area as examined below. And then one can see below under leave aside design, there's no overriding design style dominating the area. Landscape refers to the AGLV, the area of great landscape value, to which I referred earlier, and says that paragraph 30 would not result in any harm to the distinctive character and beauty of the surrounding area of great landscape value. Access, biodiversity, climate change emergency, other matters, conditions, the recommendation. So that's the report as a whole. I think going on from there, we've seen the addendum. It was what St Morgan implied our parish council was saying at page 32, and I think that was all that was being, the responses on page 33. I took your lordships to the third response, bullet point on page 33. The first two, there's a difference in opinion between officers and parish council relates to whether or not the site is immediately adjoining a settlement. So there, the officer, by the time he's writing this addendum, has appreciated the parish council's point that they're both saying it's outside the settlements, but then it's focusing on the officer saying whether the site is adjoining a settlement. If it is, the proposal can comply with policy 3, but it would not if it is not. The officer report makes clear that this judgment is arguable and sets out the reasons why officers have concluded the site is immediately adjoining a settlement at paragraph 23. That's paragraph 23 of the report. Secondly, the parish council are correct that the proposal does not comply with policy 7 of the Cornwall Local Plan, but the officer recommendation for approval is not reliant on this policy. Rather, the officer recommendation is underpinned by policies 3 and 21 of the local plan as set out at paragraphs 21 to 24 of the officer report. Then the point that I was drawing from the next bullet point about Trevarian having form, shape and clearly defined boundaries, which is why that issue about the coast road that I referred to earlier. And then the last bullet point, officers are not suggesting that previously developed land provides a mechanism to overturn the provisions of an up-to-date development plan. For the reasons set out in the report, officers conclude that the proposal complies with the development plan and there's a typing error about a landscaping condition. So that then, I think, is, for completeness, is the report, the addendum and the minutes. Well, I think...
do you want to take us to any of the debate in the as recorded?
Oh, yeah, yes. Yes, the minute, I do apologise, the minutes, I did wish to come back to that. The minutes, which begin at page 58, behind divider 5, just so that I'm being fair to what's been said, we can see page 58, two-thirds of the way down, the development management group leader outlined the application, including the showing of plans and photographs to the committee, and summarised the key issues. Then he referred to the committee update, that's the addendum previously circulated, which contained details of comments from St Morgan and Pidar Parish Council, the officer response and the correction to the officer report. And then the officer recommendation at 4. The group leader recommended that it be approved subject to conditions set out in the report. Councillor Corbett attended the meeting, was permitted to speak and spoke against the application. That's the 3 minutes that was allowed. A speaker responded to a question put to him by the committee. Mrs Wilson attended the meeting, was permitted to speak and spoke, responded to questions put. Councillor Fitter made the following points in relation to the application. He commented that the application had been called to committee at the request of the head of service. He commented that from his knowledge of the area, Beacon House had always formed part of the settlement of Trevarian. Thirdly, the application site was within 100 metres of Shrub Cottage. Shrub Cottage is on the west side of Coast Road, but to the north of Beacon House. I think it's referred to Shrub Cottage, but now it's it's divided into a terrace of three, I think, 3 separate dwellings, but it's referred to collectively as Shrub Cottage. Following the presentations, officers responded to members' questions regarding, one, officers were unsure of the exact percentage of garden that the scheme would remove.
To help you, Mr Humphreys, you don't, unless you want to, you don't need to read it out.
But it's just 6 that I referred to.
You can just bring our attention to the passages you wish to bring out.
Yeah, I'm grateful. Just number 6. Officers were of the view that Tribunals was a settlement and that the proposed site was immediately adjoining the settlement. The site of the proposed development was on previously developed land and could therefore be supported by Policy 3. The officers made clear that whether or not the site is adjoining the settlement is arguable, explained why it was arguable, and invited the planning committee to make their own judgments on this. And they thought it wouldn't set precedent for adjoining green space. A full and detailed debate ensued, the main points of which were noted, but the site was immediately adjoining the settlement, so it's the site again. The proposed development was on previously developed land, and again, that's making points I've made already. Concerns expressed that the site was outside the settlement, not immediately adjoining, that the application site and double garage did not constitute previously developed land. And then we've seen the resolution, reference to immediate adjacent, no doubt it's immediately adjoining, but very much the site. Lords, at that point, I will very, very briefly refer just to the legislative framework. I know Lord Justice Lord Lindblom will be extremely all too familiar with this, but very briefly, Section 70 of the Town and Country Planning Act 1990 says that in dealing with an application for planning permission, the authority shall have regard to the provisions of the development plan so far as material to the application. And then Section 38(6) of the Planning and Compulsory Purchase Act 2004 provides that if regard is to be had to the development plan, and we've been told by Section 70 subsection 2 that regard is to be had to the development plan, so if regard is to be had to the development plan for the purpose of any determination to be made under the Planning Acts, the determination of a planning application must be made in accordance with the development plan, unless material considerations indicate otherwise. So that's an important legislative framework. We have to determine whether an application is in accordance with the development plan and therefore to understand it. Just one other point briefly, which I set out in my skeleton argument. Regulation 8.2 of the Town and Country Planning, Local Planning England Regulations of 2012 provides that a local plan must, and I bring out some words, must contain a reasoned justification of the policies contained in it. So we have policies and a reasoned justification. So far as the case law on this approach, if I set that out at this stage, it's common ground that the proper interpretation of a development plan policy is a question of law for the court to determine. That's Lord Reed in Tesco Stores, it's Dundee. And it's also common ground, I believe, or there is common ground, that there's a need for there to be a proper understanding of the development plan. Again, that's Tesco Stores against Dundee City Council and Supreme Court. And it's in the authorities bundle divided B tab 2, paragraphs 17, 21 and 22 in particular, I draw your Lordship's attention to long established planning authority must proceed upon a proper understanding of the development plan. That follows because of Section 17 and Section 38 of the 2004 Act, and also the legal status given to the development plan by Section 38(6) of the 2004 Act. Of course, that case itself concerned a development plan policy for retail development in Scotland, at Dundee, and the issue there was it had to be shown for retail development to be acceptable that there was no suitable site in or on the edge of an existing centre. So the question arose, what did suitable mean? Was it suitable for the development being proposed, which might be a large development proposed by the applicant, or was it suitable for meeting the identified deficiencies in the retail provision in the area? So that was not, the court said, a matter of planning judgment, but logically a prior question as the issue to which planning judgment required to be directed. So what did suitable mean as a matter of law? So that's obviously of relevance to our present issue, and it wasn't just remind myself, I don't need to take your lordships to paragraph 21 and 22. I think it's common ground.
I think you can rely on the court as a whole being sufficiently familiar with those principles. I'm grateful. Just the only thing just to mention, the only matter just mentioned, paragraph 22, the Supreme Court readily recognised. They say, well, simply because the question whether the committee would have reached the same decision if they had decided that this didn't immediately join, that it doesn't follow from the views they've taken on the application thus far that they would inevitably have taken the view that yes, we'll still grant it. If one's properly appraised that, as we say, this is a breach of both policies 3 and 7 of the local plan, and that, goodness, this wording, if the appellant is right, this wording, we need to be careful because this applies to so many settlements. We don't want to create an unwitting precedent for other settlements. Then they might consider this differently. That's all the paragraph 22 I draw from that. It doesn't follow inexorably that they would reach the same decision. But your lordship in Canterbury City Council against the Secretary of State in 2019. I don't ask your lordship to turn this up. It's paragraph 22. It's the authorities bundle tab.
Well, you've written it out at paragraph 13 of your skeleton. We've read it.
Yes.
At least one member of the court is intimately familiar
exactly,
with it.
yes, exactly. It's simply the sensible meaning of the question.
We've all read it, and I wrote it.
That's right. And in the Wiltshire case as well, what Mrs Justice even said, which very much follows from what Lord Justice Livermore said. It's just one point which I haven't put in the skeleton, paragraph 27 of Wiltshire, where the learned judge said, look at the words themselves, the context in which they appear, and the mischief, i.e. the policy objective of here the plan. And I simply endorse that, if I may respectfully do so. I won't take your lordships to Mansell, which is tab B6, which shows how a committee report is to be approached. One doesn't read it as like a statute, one gives it a fair reading as a whole. And Corbett, in the previous Corbett case, divided 11B, the authorities bundle, paragraph 49, one doesn't expect a flawless discussion of every planning issue in a planning officer's report. The only other case, I think, two further cases. One is TW Logistics, which is tab B3, page 70, and paragraphs 13 to 18. The 2 points which come from this that I outlined. First of all, the evolution of the local plan, i.e. its process of its formulation, going through the various stages of public consultation and the changes from one draft to another. The evolution of the local plan is not relevant to the interpretation of policy. I refer to that for 2 reasons. One is the claimant acting as a litigating person did make arguments about the evolution of policy. And the judge, rightly, and Mr. Brett also, likewise made reference to the evolution of the local plan. But TW Logistics in the Court of Appeal does hold that and that case wasn't, I don't believe, drawn to the attention of the court, that was not appropriate. So the learned judge sets out the respective arguments by reference to the evolution policy, but at paragraph 31 said that she didn't have to form a view in the circumstances. But in my respectful submission, it wasn't appropriate at all for either side to be referring to that.
Is TEW Logistics the case in which Lord Justice Lewison referred to some kind of archaeology?
Archaeology, exactly.
And I think he was saying that we mustn't do archaeology.
That's right.
Of this kind, anyway.
Exactly. And then, and I say that because I could see the views both ways. So whichever way it went, I'm not seeking to shout out anything. I'm just complying with what I understand the law to be. The second point from TW Logistics, and again this is in the paragraphs 13 to 18 section, the court there thought that the issue, when one's looking between policy 3 and policy 7, one may decide, the decision maker may decide to give greater weight to one policy than another. And I respectfully endorse that. But equally here, as I come on to say, I'm perfectly content for policy 3 to be read in the light of policy 7. I'm not, whether one wants to say we're going to give policy 3 more weight, or whether one says, well, we read the two together, but we read policy 3 in the light of policy 7. I'm content either way in relation to that. The final case is the relevance, concerns the relevance of the reasoned justification for policy, and this is the Chirkley decision against Mole Valley in 2014, divider B tab 4A, where Lord Justice Richards, in respect to the predecessor 1999 regulations, 2012 regulations, which I referred earlier, equally there said a local plan shall contain a reasoned justification of the policies formulated in the plan. In Malone Friend Skeleton argument, paragraphs 28 and 29, he refers to the reasoned justification set out in paragraph 1.57 of the local plan. And he says in the reasoned justification, there's no reference to the word immediately in the reasoned justification, it's only in the policy, and suggests that therefore the appellant was placing too much weight on the word immediately. But with great respect, that would be to seek to use the reasoned justification to trump the words in the policy, which it cannot do according to Chirkley in the Court of Appeal, which I respectfully endorse. Clearing that away, or that, when I say clearing, just looking at that briefly, but sufficiently, I hope. Well, then comes the Cornwall local plan, which is at divider 7 of the supplementary bundle. And well, I will take this through as expeditiously as possible. Just one point on page 67, that's behind divider 7, which is internal page 13 of the local plan itself. But divider, page 67, policy 1, presumption favours sustainable development. The learned friend refers to the first column in policy 21, the presumption in favour of sustainable development. And the second paragraph of that first column begins, we will work with applicants, infrastructure providers and local community to find solutions which mean that proposals will be approved where possible and to secure development that improves the economic, social and environmental conditions in the area. Just to emphasise, of course, great respect, that the one needs to take care that it does not mean that will wherever possible approve applications means, for example, even where they're not in accordance with the development plan. It's not saying we'll try and approve wherever possible, even if it's in breach of the development plan. So I just mention that point. On policy 2, I can go policy 2A, I think, at page 73. I'll come back to policy 2 itself in just one moment. One can see that for Cornwall as a whole, policy 2A on page 73, there's some key targets set out. And number paragraph 1, just a few lines preceding that, development proposals into the period to 2030, the plan period running up to 2030, the plan having been adopted in 2016. That should help to deliver a minimum of 52,500 homes at an average rate of 2,625 per year to 2030 to help deliver sufficient new housing of appropriate types to meet future requirements, in particular meeting affordable housing needs. I think that's all I need to refer to in relation to housing. Turning on from there, the following page, in fact the following 2.5 pages, then show where that 52,500 is to be distributed. And we can see on page 76, in the end of the box with the total 52,500 in the first column under housing apportionment. That's where the 52,500. Turning back, we can go to page 74 and we can see that the foot of page 74, one needs to look at the last 3 lines. Newquay with Quintrell Downs, Newquay and St Column Community Network Area residual, and the Community Network Area total, the total being 4,800. So the Newquay with Quintrell Downs, that is, that obviously that's the town of Newquay with Quintrell Downs, which lies to its, I believe it's southeast. That area is where the major strategic growth will be. The remainder of the whole of the community network area, and I'll show your lordships that area in a moment, is for 400 dwellings only. Obviously it's a minimum of 400 because it's a minimum of 52,500. But what I'll show your lordships that area.
I'm sorry, why do we need to do this?
Well, I simply want. There's a suggestion that policy 3 is permissive. It's very positive towards development. What I wish to show is that policy 3 is in fact restrictive as to the amount of development that should take place outside the city of Truro and the main towns of Cornwall. So it's quite restrictive as to the amount in relative terms to the towns, and also it's restrictive as to the location. It needs to be going into, unless there's good reason which we'll come to, it needs to be going into the settlements outside the rural settlements, if I refer to that. And just to make this point, just to give lordships context, at page 64, behind divider 6, we have there shown that one turns, folds out, turns, the red, the black edging, if one can ignore the red edging divisions, which are irrelevant to our present position, that's about electoral divisions, but the black edging shows the entirety of this relevant community network area, where in total 4,800 dwellings are to be developed. Newquay, one can see, is in the south-western corner, that's the urban area, and Quintrell Downs is southeast, or east and southeast. And it's in that southern or southwestern area where the vast majority of that development is to go. And Trevarian is right up towards the northern end, northwestern end of that black edged area of the community network area. I simply give the context, not asking more than that, but it's just, my learned friend saying that it's very positive towards development. Yes, it's positive in the sense one needs to build houses to meet needs. But when one looks at it, in terms of being a permissive policy, yes, one can have development in this residual area, and what they're envisaging is 400 in that residual area over the entirety of the plan period. So that's 20 years from dating back to 2010. So that's 20 a year, so to speak. But it's when one looks at policy 3 and policy 7, it is also quite restrictive as to where that should be, namely within the settlements. Well, going on from that to policy 3, finally, getting there, if I may, the policy 3, which is at page 79, we begin at page 78. The policy itself. The scale and mix of uses of development investment in services as facilities should be based on the role and function of places. New development up to 2030 will be accommodated in accordance with the following hierarchy. First of all, there will be a site allocations development plan document. And to answer Lord Nimblon's point earlier, that this is why the Cornwall local plan doesn't have allocations as such. It's left to a future sort of part 2 site allocations development plan document, or neighbourhood plans. That's where local communities bring forward their own proposals for their area.
Yeah.
So first of all, it will look to a future site allocations plan or a local neighbourhood plan for the following locations, and one can see that these are all the towns, including over the page, top of page 79, first bullet point, Newquay, Quintrell, Downs. Then it says immediately after those bullet points on page 79, development at or well related to these named towns will provide an appropriate level of affordable housing in accordance with the requirements of policy 8. Secondly, next in the hierarchy are 2 eco-communities to be built for 1,500 and 500 dwellings respectively at West Carclays, Barl and Pardocks. That's in the St Austell area. That's south, the other side of Cornwall, on the south side. And then I need trouble with master plans, etc. The third point, the third in the hierarchy, comes then to this foot of the middle column, 79, other than at the main towns identified in this policy. Housing and employment growth will be delivered for the remainder of the community network area housing requirement through identification of sites where required through neighbourhood plans. There isn't a neighbourhood plan for the relevant local area here. Rounding off of settlements and development of previously developed land within or immediately adjoining that settlement of a scale appropriate to its size and role. Thirdly, infill schemes that fill a small gap in an otherwise continuous built frontage and do not physically extend the settlement into the open countryside. Proposals should consider the significance or importance that large gaps can make to the setting of settlements, ensure that this will not be diminished. And fourthly, rural exception sites under policy 9. And then 4, tier 4, within the area of outstanding natural beauty, that's one above the area of great landscape value, it's a national designation area B, or its setting, development will be supported where it is in accordance with the other policies of this plan and can demonstrate that it conserves and enhances the landscape character and natural beauty of the area of outstanding natural beauty. Now, going back to the first 4 bullet points under 3, or certainly the second, third and fourth, those concepts of rounding off settlements, previously developed land, infill schemes, rural exception sites, we get some assistance from the clarification of that policy, not trumping it, but clarification on the previous page, page 78, and at paragraph 168, and those terms are emboldened, rounding off previously developed land, rural exception sites, and indeed on the previous page 1.65 infill. My Lord, my first point is that the infill and rounding off of settlements are for sites within settlements. That's the first point. The second point is that when one comes to development development of previously developed land within or immediately adjoining that settlement, first of all, either it's going to be within the settlement or immediately adjoining. And then the final one, the rural exception sites, if one turns on to page 84, development proposals on sites outside of but adjacent to the existing built-up area of smaller towns, villages and hamlets, whose primary purpose is to provide affordable housing to meet local needs. So this isn't just affordable housing, this is to meet local needs. So if one's looking to meet specific local needs, local area, then there are rural exception sites. So that would be outside of the settlement.
Sorry, doesn't the words primary purpose govern is to provide affordable housing to meet local needs?
Yes.
So that the primary purpose must include not just, it's not sufficient just to say local need, it's got to be affordable housing.
But yes, the primary purpose is to provide affordable housing. It goes on to acknowledge that in order to make these developments viable, it may be necessary, in order to deliver this important affordable housing, to have some market housing as part of that development,
sure,
which to help fund that development. But so a rural exception site is very much the primary purpose. Where if there isn't a local need, you're not going to get any market housing. You've got to have a local need for affordable housing. For affordable housing,
yes.
That's the crucial thing.
That's the point I wasn't quite
yes,
clear on.
And they're yes, and they're saying adjacent to the existing built-up area. It might be said that because it's affordable housing, because of the importance of it, this obviously I'll propose as market housing, there is some slightly greater latitude. It's to be adjacent, obviously, to the existing built area, but not necessarily within the settlement, because it's important to meet that need. But one can see, standing back, that apart from our previously developed land points and this one point, everything else is within the settlement. So when one's looking at our previously developed land within or immediately adjoining, my respective submission is that showing the immediate adjoining means next to, in sense of, physically adjoining, the proposed development as a whole must and the previously developed land must physically adjoin that settlement. That's paragraph. I just would like to spend a few more words, if I may, on that second bullet point on page 79, because there, I referred earlier to an ambiguity, or two different ways of reading that. And if your lordships could have that wording in front of the lordships. Development, as written, it's development of previously developed land within or immediately adjoining that settlement of a scale appropriate to its size and role. Now that could mean, or could be intended to be read, development of previously developed land, which is, add in, which is within or immediately adjoining that settlement, and which development is of a scale appropriate to its size and role. Or, and this is my preferred wording, development, square brackets, of previously developed land, so that one doesn't run the previously developed land into the next bit. Development, square brackets of PDL, so development, which development is within or immediately adjoining that settlement and is of a scale appropriate to its size and role. So, Lord, I put it in that way. First, and it's because those last words, if one just begins at the end, settlement of a scale appropriate to its size and role, that must be referring to the development, not to the previously developed land being of a scale appropriate to its size and role. It must be development of a scale appropriate to the settlement size and role. That's the first.
Whose size and role is it? The settlements?
That's its size and role. That would be the settlement size and role.
Yeah.
But it can't be the previously developed land. It's what once more one reads this, one realises that one's condensed too much in. It should, in my experience, should be development of previously developed land, which development is within or immediately adjoining that settlement and is of a scale appropriate to its size and role. That makes development match up with of a scale appropriate to the settlement size and role. But it also shows that it's not, it's all too easy to say, as I've said before, it's all too easy to say, oh, well, there's previously developed land here, which in our view immediately joins the settlement, come back to that. Therefore, you can develop on this previously developed land, even though it may not be immediately joined. It should be the development being within or immediately adjoining that settlement. Anyway, that's and I've made the point that the if one interprets point 3 as meaning it's the previously developed land alone which must be contiguous, that would make a nonsense because of my point about a long access road going to a barn or a house or industrial building, which could be a quarter of a mile, half a mile in length, and yet they'd say, well, that's all previously developed land. There'd be nothing in this policy to stop it, because you'd say, well, is it appropriate to size and role? You'd say, well, yes, it's just one house, quarter of a mile down the road, or half a mile, whatever, long track. But that can't be right. It wouldn't be within close proximity to the settlement. And
Well,
that's
paragraph
why-
168 says in principle. So this is an in principle. Is that fair?
168.
Previously developed land, in principle, the use of.
Yes. In principle, the use of previously developed land within or immediately joins. Yes.
So it's the in principle that I'm addressing. You're saying that it could lead to a development of a piece of land that is a long, long way.
Yes.
Because it's at the far end
Yes.
of previously developed land. But that is the in principle would allow the planning authority an element of judgment, discretion as to whether it was appropriate
My lord, and of
for
course,
the size and role of the settlement.
my lord, yes, of course, it's the word use there, somewhat euphemistic way. Here, the use is development,
If
physical development.
your point is,
Yes.
as I understand it, is that the actual proposed development itself must at some point be, well, it'll be within previously developed land,
Yes.
but must itself at some point touch the settlement.
It
That
must,
is?
yes, it must come. If one, just to take the aerial view, just so that we can, if one took page 38 behind divider 5 of the supplementary bundle,
38.
38,
Yes.
just to, we can see the driveway. Let us imagine for the moment that the edge of the settlement was on the western side of the coast road. We say it's on the eastern side. Let's say it's to the north of the access road, to the north of the driveway, we can see there's an area which is clearly vegetated scrubland or bushes or whatever it is, but it's certainly it's not a garden area, let's put it that way, and it's not suggested that would be part of the curtilage or previously development itself. But let us assume that one were to develop along. What I'd be saying is you'd need to be the development as a whole would need to be using the land up to the western side of the coast road there. Whether it's the garden goes
Yes.
up to that point and the house and the garage and all the other things that are laid out as part of the development.
So what do you mean by the development then, when you say that it must itself touch
The development as a whole. I come back to that.
You mean the
point.
proposed
It's the
development?
physical development development. What is proposed as part of that physical, the
Well,
building
Talking about the
operation?
proposed development.
The proposed development, yes.
Can I just pick you up on that? So, am I right in understanding that if we were to consider that the third bullet, which you've directed our attention to, or the second bullet, the critical bullet on page 79, was ambiguous, we would be entitled to look at paragraph 168 to see how to resolve the ambiguity?
My lord, yes, that might shed some light on it.
If that is right, to my eyes, and it's obviously a matter of impression, and my lords may disagree, the passage on page 78, which you've just been looked at, clearly says that what matters is that the previously developed land is within or immediately adjoining the settlement. Because there's no mention of the proposed development at all.
But my lord, no, my lord, I can
What
see,
have I got wrong?
well, my lord, in my respectful submission, I fully, it's a perfectly reasonable reading, matter of impression, but when one looks into it further, the use of previously land, so first of all, we're here dealing with physical development, so it's not just a use such as ploughing the field, so it's, although that wouldn't be previously developed land anyway, but the use for development, because one needs to put in the development because, provided it is of a scale appropriate to the size and role of the settlement, one needs to be saying, well, the part of the development of the previously developed land that one's developing must be a size and role. So it's really, what is the development? Is that of a size and role? It's not, you wouldn't say, oh look, you can't develop this previously developed land because it's a football pitch in size of previously developed land, because that's far too big. We'd say, but we only wanted a small part.
The question here, surely, in both the passage in 168 and in the second bullet point in part 3 of policy 3, is a question of judgment as to whether the use or the development is, in this case, of a scale appropriate to the size and role of the settlement. And that's a matter of judgment. That's what the policy sets up as a matter of judgment for
whether the development is of size.
Well, whether yes, I mean they're clearly. I mean it's clear, isn't it, that the passage we're looking at with the bold previously developed land heading in paragraph 168 corresponds to the second bullet point.
Yes.
So it's quite clear that one is the counterpart of the other, as it were, in terms of explanation and content, and the true interpretation of the policy must involve the exercise, the acknowledgement of an exercise of judgment by the decision maker as to whether the use or development of the land is of a scale appropriate to the size and role of the settlement.
Yes.
And ultimately, that's a matter of what might be characterised as a matter of fact and judgment for the decision maker.
My lord, I have no difficulty with that.
Yeah.
No difficulty.
So in the end, the question is whether we construe the policy as meaning that the development itself must touch the settlement, or as something slightly softer than that.
Well, my lord, if I can go on to the rest of the policies as well before coming back to that, because one needs to see.
But have I set the question up appropriately?
My lord, yes, but without as long as one lordship doesn't believe he's answered it as well.
No, not at all. I'm simply at the moment we're in
the
phase of your submissions, which is headed interpretation.
Yes.
And then eventually we'll come and look at how that was actually done by way of application.
Yes.
But that's the sequence we always adopt. Interpretation and then application.
That's right. I think the. But yes, I 168 in my view is consistent.
Yeah.
My interpretation of 168 is consistent with that second bullet point as I've suggested it should be interpreted. And then coming on to policy 7 on page 83, because we need to, first of all, just to draw Lordship's attention to paragraph 2 233 on page 83. This is housing in the countryside as a heading, but 233 is where that reference to open countryside is defined as the area outside of the physical boundaries of existing settlements, where they have a clear form and shape, and we've seen already why I've suggested.
Could I ask you at this point, because I think this is the right moment at which to ask this question, does that mean, therefore, that, I'm going to use the expression by definition, coming back to policy 3, development that is immediately adjoining a settlement will necessarily be in the open countryside?
That follows, yes.
So,
if
policy 3 thus implicitly and necessarily countenances development in the open countryside.
If the settlement has defined boundaries, but when one sees policy 7, because it's so tight, because looking at policy 7, the development of new homes in the open countryside will only be permitted where there are special circumstances.
Yeah.
New developments will be restricted to replacement dwellings broadly comparable to the size, scale and bulk of the dwelling.
So to get it absolutely clear, I don't want to pin you down to language necessarily, but just want to get the concept that thus, in principle, policy 3 countenances development in the open countryside.
It does. But because of policy 7, it cannot have been intended, particularly, and that's why we have the word immediately before joining, cannot have been intended that should be given a loose interpretation, because policy 7 derives very much from national planning policy framework. Lord, if I could just pause there for a moment, since it comes up in the Braintree decision, Lord's, which is at divider B17 of the authorities bundle, where Lord Justice Limblom was a member of that court. There, your Lordship was looking at the predecessor to our paragraph 79, which was then paragraph 55 of the National Planning Policy Framework. Both paragraph 55 would have informed our Cornwall local plan, because that was 2016. There weren't revisions to the National Planning Policy Framework until I think it was 2018. So it's the same. There, at paragraph 29, Lord referred to the fact that, having looked at paragraph 55 of the National Planning Policy Framework, that case concerned the erection of 2 dwellings on the sites of 2 agricultural buildings. And the question was this isolated homes in the countryside? And paragraph 29 refers to the concept of concentrating additional housing within settlements is generally more likely to be consistent with the promotion of sustainable development in rural areas. In short, settlements are the preferred location for new housing development in rural areas. And at paragraph 31, the word isolated, in the phrase isolated homes in the countryside, simply connotes a dwelling that is physically separate or remote from a settlement. So physically separate from a settlement. So so when we come back to policy 7, that's very much saying we really are expecting everything to be in the settlements, unless you've got some the special circumstances, replacement dwelling, subdivision of existing residential dwelling. Just pausing there, there's case law that you can't divide up a garage and say, well, I'm subdividing residential building. No, it's the house which have to be subdivided. The reuse of suitably constructed, redundant, disused or historic buildings, temporary accommodation for workers, including seasonal migrant workers, so one can see or full-time agriculture and forestry and other rural occupation workers where there's up-to-date evidence of an essential need of the business for the occupier to live in that specific location. So it's saying very limited, so that when one comes to policy 3, with that, it would be extraordinary if one were going to have some loose interpretation. We know that infill must be within We know that rounding off must be within only those two other exceptions, effectively.
Forgive me, I don't understand this submission. You're not saying that policy 3 is subject to policy 7, so that if you don't satisfy policy 7,
No.
you can't.
No.
So where does your submission go from there? Don't we just have to interpret
policy
3?
7? Policy 7 helps one to interpret, is important to the interpretation of policy 3.
Another way of expressing what you've just said is if you're not within policy 3, you're not going to be allowed to develop in the open countryside unless it's policy 7, which is restrictive.
Yes, but I'm also going back.
Is that a?
That is firm, but going back from that, this was the ping pong or the whatever the
Whiff waff.
no, so it's not. They were, I think, more than private international law jurisdiction. A long time ago, with conflicts. But anyway, it's gone out of my head now. No, but coming back from that, when I was looking at the plan as a whole and seeing the importance of a plan maker, that we are really very clear about what we need to be restricted in the countryside. It'd be very odd if they said, oh, but immediately adjoining doesn't mean physically adjoin. It means whether you think this is near to or very near to or the development. The only other policy, well, I've referred to policy 9, the rural exception sites. Policy 21 is the best use of land and existing buildings. And just draw your Lordship's attention, page 85, paragraph 2.130, under the best use of land, the Cornwall Local Plan seeks to deliver a sustainable balance of meeting our community's needs and seeking to protect and enhance our environment. The plan-led system provides the best way of achieving this objective as set out in policy 3 of this plan. So that takes one back to policy 3, best use of land and existing buildings, see policy 3, and we say see point 3, and that brings us back. So policy 21 takes us back to policy 3 and part 3. My Lord, sorry. 2.131. Oh yes, 2.131. The importance of the countryside, defined here as the area outside of the urban form of settlement. So this is both countryside and open countryside deemed to be. Ranges from its value as agricultural land, for its landscape value, its biodiversity, and historic character. I would also simply add this, that it's well known, and national planning policy for many years has been that, obviously the area of great landscape value is a landscape designation. It's a local landscape designation, it's not a national one. National planning policy has for long recognised the intrinsic character and beauty of the countryside, whether it has a landscape designation, whether national or local in itself. So I'd add that to that. There's just one other point to raise. My learned friend, at one point, there was some reference that there was a reference to policy 8 of the local plan. I don't know whether the learned friend is going to be referring to that.
It's not one I think that you mentioned, is it?
It's not, but I just may I reply to it if it is mentioned?
Yes.
I don't want to shut out anything.
No, of course not.
But
if it does come up, then of course you'll have the
simply,
opportunity.
I don't intend to refer to policy 8.
All right.
marvellous. Thank you very much. Thank you.
Thank you.
So
and 21. Then you
Oh, sorry.
want to say anything about that, or you?
20. I don't to ensure that nothing. It's
Right.
used previously developed land and buildings. I don't think it takes any further.
Okay.
Clearly, previously developed land is part. We've already developed this, so we think, well, that's somewhere where it's deemed in policy to be. If we can make good use of that, rather than taking further greenfield sites. One can understand the policy objective there. But in terms of bringing the settlement policy, and after all, it's looking first and foremost to previously developed land, let's redevelop the old garage site or the old pub or the old bakery, whatever it is, within the settlement on previously developed land. We ought to be focusing on that. If it's not within, it should be immediately adjoining. We say that's all consistent with a piece of policy settlement.
Right. So, where do we go next?
Right. Well, that's I think then I've already made the submissions relating to policy 3 and policies 3, 7 and 21. I come to this, the dictionary definitions of the word adjoining, which the judge noted include next to or very near, are not, in my respect for the submission, determinative, nor in any event did the dictionary definitions before the court address the relevant phrase immediately adjoining. And I've looked to see if there was such a definition in the dictionary, and unsurprisingly, there isn't. So it's not enough to say, well, adjoining can mean, depending on the circumstances, contiguous, adjoin. If we were back at school a long time ago now, but adjoin, and the Old French or the Latin, one would have said join to, physically join. But one recognises that over the resulting decades that language does change, and that depending very much on the circumstances, it can be used to mean adjacent. Adjoining can mean adjacent, very near. So, but here I accept that. Here we've got the words immediately adjoining. It's not enough to say, oh, well, let's take the definitions of next to or very near, and that the word immediately doesn't add anything, which is what the learned judge said.
You say it's a qualifier and not tautologous.
That's right. Yes. Right. Yes, I think the reference to coterminous, which would have an O in terminus. I made my typographic error in my skeleton. Same or coincident boundaries, or contiguous with touching, if one looks at the Oxford English Dictionary, as well as adjacent, etc. And then I think when one turns to the learned judge's judgment, if we turn please to divider 5, this is on the core bundle, divider 5, page 70, we have the judgment. Yes. I just mention a few points as we go through. Paragraph 19 on page 76 of the bundle. As I explained below, in my view, however, the reasons Mrs Justice Lang gave for refusing permission were right and are sufficient to dispose of the judicial review. And her words are at paragraph 17. In my view, the claimant's narrow and literal interpretation of words immediately adjoining the settlement is unarguable. The meaning of the phrase immediately adjoining is wide enough to include next to or very near. The local planning authority had to make a planning judgment on this issue in this case in the light of the evidence available to it. That judgment cannot be challenged absent an error of law. Obviously that was at the permission stage, and Timothy Moylan, Queen's Counsel, sitting as a Deputy High Court judge, subsequently looked at these papers and thought there was an arguable case. But paragraph 19, second sentence, Mrs Justice Lang clearly did not mean that the words could be given whatever meaning the defendant chose, but rather the words had to be given a sensible meaning, which included next to very near. And whether the site fell within that meaning was sufficiently next to or very near, then involves an exercise of planning judgment. I refer to paragraph 19A, that's dealing with those questions about the meaning, but also that reference to the site itself falling within that meaning rather than the proposed development as well as the site. My Lord, in terms of the wordings, the dictionary definitions, we see that at page 77, paragraph 26. I don't need to refer to that again. Paragraph 28, I do not consider that the addition of the word immediately changes any of that. Fourth line, in my judgment, that places too much weight on a word that does no more than reinforce the word adjoining and indicate the element of judgment in whether a site is or is not adjoining. And just pausing there, my respectful submission, if my reading, if my submission is correct, that it means physically adjoin, as one would expect, directly adjoin the site, then that doesn't involve any substitution of words at all to the policy. And there's, recall many years ago, late Lord Justice Laws referring to the danger of foundering on the rock of substitution. I think that was in the Persimmon Homes case. That was a statutory interpretation case. But I just, so one needs to be careful, with great respect, that one isn't substituting a new test. And of course, in effect, it seems as though the planning officer, having said it was arguable, then brings in an additional wording for additional test.
Just pausing, I confess I hadn't recalled that characteristically pithy statement by Lord Justice Laws. It does capture perhaps an essential truth. You won't have the reference to hand now, I don't suppose, but if you could bring it after the adjournment, I would personally be very grateful.
Yes, and I hope I haven't misremembered.
Well, it sounds, I think, if I may say, Lawsian, the way that you did recall it.
Well, as one of his many pupils, I remember that with great fondness and great respect.
Of course.
And I was a junior counsellor in that case, that's why I particularly remember it. So I think it's 2005, but I shall dig that out.
It's the Persimmon case, is it? Did you say?
Persimmon Homes, yes.
Yeah.
What the words general conformity between general conformity and structure.
Well, I'll have a look over the adjournment, but if you could do the same, that would be very kind. Thank you.
So yes, that's the. With fairness to Mrs Justice Jefford, she didn't say that the dictionary definitions were conclusive on their own, but so I don't rest at that point. One looks at the context, and we've seen the word in Policy 9 being adjacent. So obviously one's got to be careful. It's not construing the local plan as a statute. Nevertheless, we thought the word adjacent there was appropriate, but immediately adjoining, and there's nothing in my respectful submission suggests that immediately adjoining should just be very near, even when one's looking at paragraph 1.68 and that reference to the previously developed land, use of previously developed land. The judge at paragraph 28 gave an example This is halfway through, this paragraph 28, page 78. Having said that, in my judgment, immediately, you're placing too much weight on a word that does no more than reinforce the word adjoining. To take an example, there may be a settlement with some area of green space. Assuming there was no argument that the green space was within the bounds of the settlement, a proposed development on a site adjoining green space would be adjoining the settlement, but it might be argued that it was not immediately adjoining since it was further from the built element of the settlement. As I've said in my skeleton argument, that with great respect, that's erroneous because, first of all, the learned judge's example was a site within the settlement. Here, it's common ground. The basis for the decision was that we are not within, the site is not within the settlement. And Policy 3 plainly doesn't distinguish between built and non-built elements within assessments. And the development in the example would immediately join the settlement, whether that means join or be next to or very near. So the second example that the judge gave us at paragraph 43, where she accepted the argument put forward by the council.
43.
43 on page 82.
Yeah.
As the defendant argues, within what is accepted to be the settlement itself, there are roads, as one would always expect. Yet it's not arguable that the settlement of Trevarren should be regarded as a series of subdivisions because developed areas are separated by roads. Necessarily, therefore, there is an issue as to whether a road is part of the settlement or not. And so the assumption, and indeed at a number of places, she's saying, well, the question of what is the settlement, that's a matter of fact. And, but in this case, the basis for the decision was that the coast road was not part of the settlement. And so it's only the eastern side of that coast road which is the settlement boundary. And a coast road, obviously a coast road, and one thinks just standing back to around here, everyone says that's the coast road. So that's consistent with not being part of the settlement. But also, so we're not dealing with roads, obviously roads within assessments, main roads or cul-de-sacs or side roads or residential roads. Clearly, those are within the settlement and are divided. The coast road here is very different from, and I think with great respect to the judge, she may have been at that point misremember or overlook the fact that the basis of the decision, was that this was not within Trevarren, it was not within the settlement, and the officer had said that between the site and the settlement was a road. And so again, one needs, in my great respect, I understand obviously the learned judge's views are very clearly set out, but in my respectful submission, there are some errors there which may have affected the overall position. Paragraph 48, for example, again saying, referring to the site rather than the proposed development. Paragraph 49, whether the site falls within that meaning involves an exercise of judgment. So, I don't, obviously, the court will reread what was said, but in my respectful submission, I come back to the simple point, immediately should be given. Weight, it clearly does mean, in the context of Policy 7, clearly does mean physically adjoined. I'm not saying that the building itself must be right on the other edge of the road. I'm not saying, I'm saying the development proposal as a whole. Development proposal, the building and the garden, everything else, does that
if
immediately join.
I'm so sorry for interrupting. If the garage had been located immediately by the road, and in all other respects was to be developed as it is now. Would you accept that in those circumstances it was immediately adjoining?
Well,
If it's next door?
so it's the other side of the road, and the road.
No, it's on the same side. So it's on the wrong side of the boundary, as you express it.
It's still to the west of the road.
Still to the west of the road, but it was right up at the end of the drive.
That wouldn't be immediately adjoining.
You say that would not.
That would not be because of the road. Well, my lord, residents love their county. We all, as tourists, if we go there, love the county of Cornwall. There's a particular reason why it's lovely, and one needs to be very careful. That's why the words are important.
But I'm conscious.
Policy, of course, but I can't. But I saw your lordship's cheeks blowing out. But
And you were right to interpret it as meaning that I didn't immediately accept your submission.
and that's why I thought I would put my foot in the door. If I may. I'm saying that that's.
Basically, you're saying if there's a road which runs along the boundary of a settlement, it is impossible for anything outside the road or be on the wrong side of the road.
Well, if the road is not part of the settlement, if it's part of the settlement, that's fine. But here, the coast road is not. It's the eastern side which marks, and that's what the office. That's the basis of the decision.
I know.
And also there is. If I've just turn up whilst it's in my mind. Paragraph.
Sorry, just pausing while you're looking something up. If I could just come in on that last point. You said if it were part of the settlement, it would be different. Here it was the coast road, i.e. a through road from A somewhere else to B somewhere else. Whereas had it been, as it were, an estate road, for example, within the settlement, then that would be different.
Yeah.
So what a different case, of course, some sort of circular road around a settlement. What about that?
Circular route. Well,
Some sort of mini bypass, as it were. Maybe we needn't get into these.
no, I think it's yes.
Well, let's not then. Let's not go there.
Well, I think I quite rightly one tests my argument. It's very important to test, and that's why I spend a lot of time testing it. And that's why I look at this. I mean, first you think, well, if there's a hedge, a thin hedge, half a metre width, you're saying that's not. You say, look, there's a de minimis principle, trivial. But the question is, if the garden or the build, if the building could be along the edge, but if it's the garden which is being laid out, which goes right up to the boundary, or the settlement boundary, that is, then that is the proposal as a whole. It's all facing. It's a matter of judgment that you've got a house and a garage and the garden in front. As a matter of judgment, does the development proposal as a whole immediately join? Yes, the decision making decides because the garden which has been laid out, goes right up to that edge. We leave aside as trivial the fact that there's a narrow hedge, which is the existing boundary. If, however, I turn the development 90 degrees and I've only got one part of the development there, you might say, well, the development as a whole is not, for example, is not as a whole immediately joined. It's only one point which touches, but really it's all over here. So that would be a matter of judgment for the decision maker. That's where the judgment comes in. But in terms of immediate join, physically join, simple, straightforward, that's what you're looking for. What the danger is, particularly in paragraph, as we see in policy 3, the wording, unless one thinks, what does this actually mean and why? The danger is one gets different committees taking different decisions and suddenly, oh, that's been granted up there and it's repeated too often. And so that's why it's very important to look at this this wording. Why put in the word immediately if it simply means near to? And looking at this, if one looks at the aerial photograph, I know that's an aerial photograph, it says, would one say that land there immediately adjoins? That would be, on my interpretation, plainly it couldn't be said to immediately adjoin.
What do you say about the use of the word settlement? In other words, settlement is a sort of rough concept. So you might say so to take one example, if something has to immediately join a particular property, or whether something immediately joins a city. There's a spread of potential interpretations in different contexts.
Yes.
So why do you say that for something to immediately adjoin a settlement, it has to physically connect with
well, my lord,
the settlement at some point?
Well, first of all, settlement here, there can be settlements which don't have any shape or form, and policy acknowledges that. So we're dealing with a settlement where it does have shape and form, so that one can actually define it, and therefore the officer was able to say this is not within. But
I understand.
But coming on to your point, if this were on the edge of a town, I mean, one has to be careful, because policy 3 is on page 79. It begins, policy 3, part 3 begins, other than the main towns.
I appreciate that. I'm just saying that the expression immediately adjoining might have different connotations in different situations. So that was my sort of lead-in, if you see what I mean, to my question, which is, why do you say that for something to be immediately adjoining a settlement, it has to be physically connected to the settlement?
Well, it's because outside the settlement, it's going to be deemed to be open countryside. If you're outside the settlement, then it's open country. That's what the policy says.
But that's circular. That's completely circular, because we've established about 20 minutes ago that policy 3 is going to be talking about being outside or being in the countryside.
Policy 3 in 2 elements will be outside the settlement, but it's got to be, we say, physically joined. But I certainly didn't intend. I hope I wasn't circular. But it doesn't matter what the settlement is. The same principle applies because of the way the policy says that if you're not outside a settlement, is to be deemed to be open countryside, and therefore that's why it doesn't matter the size of the settlement, as long as it's not one of these main towns, for example. The same principle applies there. One doesn't want to see settlements expanding into the countryside.
I understand, but one answer to that is that's why the expression that's been used is immediately adjoining. Not physically connected to, but immediately adjoining. So I'm trying to work out why, in order for something to be immediately adjoining, it has to be physically abutting the settlement.
Well,
other than just saying, well, that's what it means. Do you see what I mean?
Well, I'm trying to work out why. I'm sorry about it. Sorry, it's the. It needs to be physically connected because we're seeking to save the countryside. We're seeking to make it easier for people to leave their cars behind, and indeed not even to use any form of motorised transport, to walk to facilities and services, and so it's both it's sustainable development in all its senses, in terms of accessibility and saving the countryside, which is a very important environmental consideration.
Right. So if I was to write down, in order for that expression to be appropriately prescriptive to achieve its objective, as you say it is, it means, or it must mean, physically contiguous.
Yes.
Otherwise, it would not be appropriately sufficiently prescriptive to achieve its objective.
Yes.
Is that
My Lord, yes.
right?
Well, if I may briefly refer to, only very briefly, to the decision of the Court of Appeal in McGaw and Welsh ministers, I've set it out, the relevant parts in my skeleton argument, and I really clearly there was a particular statutory instrument, the Town and Country General Permitted Development Order 1995, then was, and the words were immediately adjacent, and that was, you had permitted development rights, but the height of a proposed building in the garden of a house couldn't exceed a certain height, and that height was to be measured from the surface of the ground immediately adjacent to the building.
Right, and that's an example of context because it's referring to the ground, and you can't dispute what the ground is. Do you see? I mean, it's a precise, absolutely precise word in the context.
Oh, yes, well, but in terms of yes, the ground, but was it? Which ground was it?
I know.
I know.
Well, it'd be silly to say, well, there isn't any ground because there's a wall. Well,
Exactly.
That would
So you have
be nonsense.
You have to find the next nearest.
Yes.
That's the interpretation of a piece of legislation, isn't it?
Exactly. I'm only referring to it, my Lord, because
Yeah. Well, you're entitled to refer to it, of course, not only because it's there, but also because Lord Justice Lewison referred to it in granting permission.
No. I know exactly what I'm not. I'm saying that that's an example of where it immediately and adjacent there meant physically touch or as near as possible.
It had a particular meaning in its statutory context. Is that a fair way of putting it?
That's exactly right. But and there it was very interesting that the learned judge referred, I think it's Timothy in that case, referred to on that focus on the words immediately as well. Anyway, I don't need to take further on that because we come back to the particular context here. The other case, cab housing, which is the last, Mrs Justice Holgate.
I think that's on appeal, isn't it? To this
I was just about to say that. I noticed on Westlaw it now says subject to appeal. But there, that again was a permitted development order. There, a recent permitted development, relatively recent, where you can extend upwards by 2 stories or 1 story if it's a 1-story building without the need for permission, subject to prior approval. And the question, and it's paragraphs 81 to 85 and 102, little Roman 3, if I just refer to that. But again, in context, the learned judge said that adjoining included adjacent or neighbouring in that case, but he was looking at particular provisions as to whether concerning notification and what one should have regard to. But he said that it was more significant that where the draftsman meant to say immediately adjoining the order, he used that express language.
Sorry, where are you reading from?
So paragraph 82.
82, sorry, yes.
No, and it's. I don't wish to take snippets out of a judgment. It needs to be looked at as a whole. It is a lengthy judgment, but I think the relevant passages for our purposes are from 81, where he's considering the words adjoining premises, internal page 23, to I think I said up to 85. There's a section there. But just to say that in paragraph 81, he refers to paragraph AA23A1. My Lords, if I could just give your Lordships the reference, that's on paragraph, set out at paragraph 5 of the judgment. And the wording there that one had to, before beginning the development must apply to local planning authority for prior approval as to impact on the amenity of any adjoining premises, including overlooking privacy and the loss of light. That's paragraph 81. When one gets on to paragraph 84 of the CAB judgment, there's a reference to paragraph AA.3. Your Lordship's reference, that's set out at page 33 of the judgment, where the judge has appended the relevant part to the end of his judgment. But just one can actually see the wording there that he was then referring to at paragraph 84 about notifying each adjoining owner or occupier. But again, very much in the particular circumstances of that particular statutory instrument. And it doesn't get me homey. I need to cut it. Shows that the words can mean adjoining. It all depends on the particular context, what it means. And I can't improve on my point about immediately. May I just, my Lord, just briefly say, although I'm happy to see it past one, may I just give an indication? My second ground, when I first got the papers, I realised subsequently I didn't have all the papers, all the skeleton arguments from Mr. Corbett, which have been submitted. There's no criticism of him. But I didn't realise that, in fact, my second ground had, in effect, been raised already by him in his skeleton arguments twice, both before Timothy Moylan, Queen's Counsel, sitting as Deputy Judge, and also before the learned judge below. And so, in my suspicion, the point I'm raising, ground 2, is not a new point. It doesn't involve any new evidence. It doesn't put anybody to any particular friend of the Cornwall Council to any disadvantage to address it. It's a matter of looking at the documents that we have and what is the correct interpretation of law of policy 3. But I do say that the wording in paragraph 23 of the report to committee, saying is the tests there set out, which aren't tests in policy 3, that they were an irrelevant consideration, and obviously that, however one defines the words immediately adjoining, they were irrelevant. Immediately adjoining is really a physical concept, not, as in part the officer seems to proceed upon the basis it also had a functional concept, whether it's